The third way, a strategic exit from the divorce court mediation loop. Divorce cases spiral and stagnate because the system allows delay without consequence. Courts are overloaded. Mediation, as it is usually structured, does not require resolution. Without pressure or a real endpoint or incentive, people circle the same issues over and over. At some point, most people hit a breaking point. Mediation works until it doesn't. Costs keep climbing. Early, imperfect decisions at the temporary orders level start hardening into permanent outcomes. And you realize the default path, more mediation than trial, isn't really a plan. It's drift. There is another option, a third way, ARB-MED. ARB-MED is short for arbitration followed by mediation, and it flips the sequence. Your case is fully decided first by a neutral arbitrator. That decision is written, finalized, and then sealed, but held in reserve while you try to settle next. This takes your case out of the court system. You are no longer stuck in backlog, delay, and procedural drag. The arbitrator also serves as the mediator, which matters. By the time mediation starts, that person already knows your case. There is no time wasted getting anyone, parties or mediator, up to speed. Here's how ARB-MED changes the physics of your case. First, preparation is front-loaded. You do not show up with something that is good enough for mediation. You build your case the way you would for trial. Financials, parenting proposals, evidence, all of it. Second, you have a private hearing. Both sides present their case to a neutral decision maker on a defined contractual timeline. No court calendar, no endless continuances. Third, the arbitrator issues a binding decision, but you do not see it yet. It goes into a sealed envelope. Fourth, you go to mediation, but now everything is different. Both sides know a final result already exists. The bluffing drops, the posturing fades. Negotiation becomes real because the alternative is not uncertainty. It is a result that has already been decided. That forces discipline. Both sides have tested their positions under scrutiny. They understand the strengths and weaknesses of each other's cases, and they also understand the strengths and weaknesses of their own case. Mediation stops being theater and becomes problem solving, real problem solving. There's also a hard stop built into the system. No loops, no resets. If you settle, the arbitration decision is destroyed. If you do not, the envelope is opened and the decision becomes the final resolution. Either way, you know how and when the case ends. There is a trade-off. ARB-MED is not a free lunch. You have to prepare your case seriously from the start, and you give up the ability to drag things out indefinitely, but so does the other side. In exchange, you get the momentum and certainty you want. You stop the slow bleed of time, money, and energy that comes from not knowing when the process will end. Process drives outcome. If the structure allows delay and rewards posturing, that is exactly what you will get. ARB-MED is different. It rewards preparation. It penalizes stalling. And it creates a path to resolution that actually moves. If you want a system that does not just manage conflict, but resolves it, this is the option that should have been on the table from day one.